So the question now is that Part 1 as amended stand part. Those of that opinion will say aye. Aye. Contrary no. The ayes have it. The question now is that Part 2 stand part. This is the debate on clauses 13 to 19. Charles Chevelle.
Thank you, Mr Chairman. Mr Chairman, the commentary from the Law and Order Committee contains a helpful explanation of the rationale for this part of the bill. And I'd just like to quote from the penultimate paragraph of the commentary directly, because it probably is the best way to give members who aren't familiar with the legislation and those listening at home an idea of what Part 2 is designed to do. Concern was raised in 2010 when a self-represented defendant corresponded with people whose names and addresses were on the jury panel for his trial. The bill is intended to address this problem by amending the Juries Act 1981 to allow some information to be excluded from the jury panel. It would be called protected information, and access to it would be restricted. And the committee goes on to note one recommended amendment in respect of police employees, which probably isn't material for the purposes of the discussion. So the scheme that the amendment bill would put in place is that it would create or turn jury panel information into protected information or protected particulars, and then it would go on to restrict the types of people who could get access to that information. For example, a barrister or solicitor acting for a party to the proceedings, the Crown or other prosecutor in criminal proceedings that are due to be heard during the week of the trial, what have you. Now, and then there are restrictions placed throughout the rest of the legislation on how those people who can get access to this protected information are then at liberty to use it. Now, the reason that members on this side of the House have decided to support the bill is that we think that is a helpful way to strengthen some of the protections that are contained in the legislation. We, however, are concerned that there isn't a total protection provided for, and I would be most obliged if the Minister would take a call. She may want to get some advice from the officials, but there are clearly categories of information which remain outside the protection. Well, look, National Party members, by their interruptions, are just conceding the fact that this is not legislation that they regard as a priority. They've let it languish on the order paper since May last year. It hasn't been progressed with any expedition. If they're actually serious about improving the jury system, they might just want to consider what this legislation fails to do. And here's what it fails to do. A person who's determined to stalk a juror can go along to the trial of a jury trial. They can sit in the well of the court, because generally we hold these proceedings in public for good reason. And there are all sorts of ways that the particulars of a juror can be obtained. These days they can be Googled, they can be looked up in the phone book electronically or otherwise. There are all sorts of ways that a person who is absolutely bent on making mischief in respect of a particular juror could find things like their home address, their particulars for correspondence, and then effectively have communications with them outside the jury system. That's the very evil that this part of the bill is designed to prevent, and it seems that nobody's really given a lot of thought to the way things work in the age of Google. So we might, for example, have considered in this legislation extending the protections provided for jury particulars by, for example, making an offence to conduct your own research for purposes not connected with a particular trial about an individual juror, at least about that person's home address or particulars. If we really were concerned in the House here, and if the government were really concerned about protecting jurors in a meaningful way. But nothing like that has been done. There is only a limited protection on a sort of paper-based, old-fashioned basis for that information. So I think when members are considering this legislation, they are going to have to consider the rather slapdash way it's been advanced and the fact that it really only, Mr Chairman, it really only does advance a partial protection along the lines that I've described, rather than the sort of fuller protections that one would expect in the information age. And I think it's relevant in this regard just to reflect on the fact that the Minister, in her other capacity, in her capacity as Minister of Justice, has before her a report from the Law Commission concerning privacy and information management in New Zealand. And these are the exact sort of issues that the Privacy Commissioner pointed out to the Minister. The Minister has accepted some of those recommendations, but by no means all of them. And this is probably a very, very good example of the sort of situation where, given that we are in the age of Google, we do need to think a lot more laterally about the sort of protections that we can put in place around people who are performing a public duty like jury service, where they are effectively putting themselves out there in a situation where they can be at risk, as the evil that this bill is designed to address demonstrates. But it's no good simply providing partial protection. Just as in the privacy area, it's no good for the Minister to say, well, I'm going to pick and choose out of the Law Commission's recommendations. I quite like that one, but I'm not going to do what they recommended here. That was an holistic approach to information management and privacy in the age of Google. It did say things like you need to give the Privacy Commissioner powers to order compliance, powers to audit where there is a suspicion that unsatisfactory practices are occurring with information management. And yet we still don't have a commitment from the government on those issues, because I don't think the Minister or her advisers fully understand the ramifications of that report. Just as here, we have an incomplete protection for jurors who do a fine job, who do deserve much fuller protections, indeed the fullest protections that we can give them as we respond to the technology and the challenges that they face. So, Mr Chairman, we will be supporting this part because there is no doubt that the protections are greater than they are now. They do respond in part to the case back in 2010 that's referred to in the commentary, but they by no means provide as full a protection as we might be providing them, and I fear we'll be back here doing this job again in a couple of years because for whatever reason there wasn't enough thought given to the sort of protections that we ought to provide jurors for doing the fine work that they do.
Jackie Dean.
Thank you, Mr Chair.